milady.
Yeah, so in the interest of time, you don't need to repeat. I've got regard to, I'll have regard to your heads of argument, so you don't have to.
I hear you, milady, and I won't. I just want to say one thing on the jurisdiction point.
Yeah.
Of course, we respect the decision in Ledler. I know that the decision in Ledler stated that the tribunal has jurisdiction to entertain legality reviews. The only thing we say to milady is this: to the extent that you find, particularly in respect of our client, SA Fence and Gate, one, that it did participate in a competitive tender, which it did. You won't see anything to show that our tender process or the bidding was not competitive, and I'll deal with my learned friend Sarah point shortly. To the extent that you find that, therefore, the only way that this can somehow fail, or the way that the agreement and or the tender can fail, is on constitutional precepts. The only thing I would ask milady to have regard to is this: that if one looks at section 172 and what the court may do, this is exactly what they're asking milady to do. It says, when deciding a constitutional matter within its power, and I would submit, milady, the failure by the IDT and or the DCS to comply with either the PFMA or constitutional prescripts and provisions is a constitutional issue. Now the question becomes, Ledler's got to be accepted on one thing. It has stated that the tribunal is not a court. That's not under challenge by anybody. To give it proper meaning, one then says, well, what can the tribunal, based on Ledler, and we may have our views, my views that Ledler's wrong, because I say that even a common law legality review should only take place before a court for the jurisprudential reasons that we're not going to debate now, milady. But as things stand, in Ledler, there was evidence of fraud. And that's really what the case was saying, that milady and other members of the tribunal can hear a review because of the breadth of the wording of the SIU Act. What we do know is the SIU Act doesn't specifically speak of review, it speaks of civil proceedings. That's fine. If, however, milady, one goes to look at what they want in this case, when deciding, this is 172.1, when deciding on a constitutional matter within its power, a court, now those words, within its power, a court, it's got two things. One, a reference back to 166 of the Constitution, of what a court is.
Don't re-argue Ledler, which is what you're doing, Mr. Polo.
Let me add just one point to this, milady. It says, must declare that any law or conduct that is inconsistent with the Constitution is invalid, and the extent of that inconsistency. Always saying, milady, if you're going to rely on constitutional precepts, strictly speaking, Ledler has not conferred on the SIU tribunal that jurisdiction. I don't take it further. It's in our heads, and milady obviously is free to disagree with it. And of course, one day the Concourt is the only party that can possibly deal with this any further. Milady, but more importantly, if I can deal with two things, in fact, three things. First of all, as I mentioned, SA Fence and Gate participated in a proper tender process. There's no suggestion that anything else happened. Secondly, milady, if you look at the founding papers and everything my learned friend submitted to you, he's not submitting that at any time SA Fence and Gate was in cahoots with Manieletti or anyone else. His only submission to you as a criticism of SA Fence and Gate is one submission, milady, namely, they were helped by Manieletti by ticking those 4 boxes about the SIRIF certificate. Now, milady, what was submitted to you was that every member of a JV requires to have a SIRA certificate. That's not accurate, milady. And what I'll show you, milady, is that our clients, SA Fence and Gate, had a SIRA certificate. That's common cause. My learned friend confirmed it, as did another member of the JV, and that's sufficient, milady. If milady would please consider page 001-1581. You don't need to necessarily turn it up. My learned friend referred to it, but I can read you, milady, what it says. This is paragraph 20 of Mr. Du Toit's affidavit. Quite importantly, milady, for motion proceedings and how one makes out a case and how one shouldn't, based on the Swiss Bureau and other cases, simply...
Page reference again?
Sorry, milady, 001-1581. If I'm not mistaken, it's paragraph 20 of Mr. Du Toit's affidavit that my learned friend quoted. Bear in mind, milady, this comes as one of many, many annexures in voluminous annexures. This criticism based on SIRA was not in the founding affidavit of the applicant. It's an annexure, quite obscure, but milady, in any event, I'll submit to you and I'll show you why we didn't have anything to deal with over here. No, there's no allegation here. If my lady looks at paragraph 20.1.9, one of the requirements for this is a certified copy of SIRA by SQ members of a JV. It's only specific members, not all members of a JV, as my learned friend submitted to you, by the SQ members. Now, my lady, if one goes back, and by the way, my lady, the SQ member of our JV and the leader of our JV was SA Fence and Gate Holdings, I think, or Investments, I think it was called. And my lady, if one goes then to also an annex, my learned friend cited to you.
What is SQ? What does SQ stand for?
It's a CIDB grading to do with certain qualifications that you have to do security work. But SA Fence and Gate had that, my lady. And they don't all have to have that, because my lady will know in a joint venture situation, typically joint venture partners, especially in the BEE realm, might have different value adds that they bring to the party. So it's not the case that every time one needs to have an expert in security and then everyone else must be an expert in security. Others could be experts in construction, like Robex Construction. So, my lady, let's go back then to Annexure CDT 17, which is an annexure to Mr. Du Toit's affidavit, where he gives us more color. And my learned friend cited this to you. It's at page 001-1767. And at paragraph I comes the very same thing. Certified copy of SIRA certificate, as well as a letter of good standing, brackets, at least the SQ member of a joint venture needs to supply these documents. So, my lady, that dispels the question, and we would have dealt with it with much more chapter and verse had they put it in their founding papers like they should have, in the main founding affidavit. Had that been a reason to say, and they don't say it, my lady, anywhere in their papers, that this is a reason to disqualify SA Fence and Gate, would have been dealt with. SA Fence and Gate had the certificate, it's common cause. And in fact, one other member of that JV also had that same certificate. So, my lady, if that's the worst criticism we can have of having somehow been helped by Manueletti, let's go and analyze that. Manueletti, and it seems to be wrongly, ticked 4 boxes. But the truth is, my lady, the evaluation and the adjudication committees would have seen you only need to tick 1 box as the SQ specialist. We're there, we've ticked that 1 box, and they would have not disqualified us. So there's nothing before you that the applicant has put that could possibly have disqualified SA Fence and Gate either on flawed or any other recognized review ground at common law. The same too, my lady, compliance with constitutional precepts. Nothing tells you that SA Fence have done anything wrong insofar as constitutional precepts and provisions are concerned. They qualified, they won the tender. They were not appointed, my lady, by Manueletti. They were appointed by the IDT. And there I must concur with my learned friends who argued that the IDT is where one should be looking if one wants to punish somebody for what happened. And one certainly shouldn't be helping the IDT disgorge back profits. I'll deal with the profit issue as well, because my lady, I just want to make one point on that, and I won't repeat what my learned friends have argued to you. But the simple point I make to you, my lady, is this. Before you is not a case where, certainly not on motion, and if you're in doubt, my lady, then refer it to evidence, where anyone can point a finger at SA Fence and Gate. There's not a single thing they did wrong. There's no suggestion of collusion with Manueletti. I've dealt with the SIRA point of my learned friend that could have been the only hint of some form of collusion. I understand what he was saying, my lady, but it's not there. And my lady, on that then, turn a whole lot of other things. One is it fair to even cancel the agreement? Because let's analyze that. They won a fair tender. No one's shown it's unfair. As far as they are concerned, I'm not talking about Manueletti's appointment or anyone else. Manueletti did some form of professional work to enable the IDT to appoint us. They appoint us fair and square. We do the work for tens of millions of rands, my lady. We work from 2012 to January 2018. In January 2018, and by the way, my lady, this goes to delay as well, and fairness in delays, Buffalo, municipality case, and various others. They allow us to do all the work for many millions until 2018 January. I hope my lady didn't take the boring exercise of reading all the Pretoria papers, but in those particular papers, what the applicant there was saying, the IDT, is not, what it was basically saying is that our agreement was cancelled, because what happened in January 2018 is, in desperation and at their wits' end, SA Fence said, we are not being paid many millions. You're bankrupting our JV. We can't do this anymore. We have to stop work as the agreement gives us a right to do. We can suspend the works, and until you pay us on certificates. And by the way, in a bracket, my lady, we had been issued by Ramgulam certificates for all these payments. There's a pending case where we're claiming on certificates. So we actually got held back payment on certificates. That's the first salvo fired by the governmental agencies, and I'll deal with what they've done and not done in the 8 years that they took to get this, or 11 years to get this towards you. But my lady, very crystal clearly, we then had to stop. What they then do is, in May of that year, I think it was May, they then say, no, you see, you've suspended. You're wrong to suspend. We're cancelling your agreement. Not a peep of tender fraud, remembering that since 2012, in 2018, when the Pretoria case was started, there have been 6 years with all that machinery that my learned friend mentioned to you earlier that the state has to investigate, all the cross communication between Treasury, Auditor General, IDT, DCS, SIU was already in existence in 2012. All of that time, we invest tens of millions of rands of resources to comply. What did they come? Their best salvo? No, there wasn't any tender fraud. We're cancelling because of non-performance. That's what they first tried. Then came a case before the Pretoria court where suddenly we were fronting, we had lied about the status of our joint venture. Where's all that gone now? So, my lady, they've changed the goalposts all along with only one thing in mind: getting rid of these honest tenderers and putting new tenderers in their place. And guess what? We call them on it. We say in our papers, put up the budgets that you're now using to do that very same completion work that we were meant to do. They don't do that. So we've played open cards with the court in Pretoria, with yourself and the SIU insofar as this matter is concerned, with all of our learned friends, including our opponents. All we've ever said, and my lady, by the way, after they purported to cancel in May of 2018, we still spent time keeping security on site, safeguarding all the materials that government had been charged for in our unpaid certificates. We kept people employed, thereby doing all the things that one should be doing for employment equity and triple BEE. We did all those things for a further 2 years, my lady, until guess what happened? They threw us off site. We then had to bring a spoliation application, which failed. Why did we fail? The court found, no, you weren't in peaceful and undisturbed possession. Fine. It's a judge's finding. We didn't take it further. Nobody has got unlimited funds to fight court cases. But the truth is, my lady, this honest tenderer did everything in its power to stay on site. It didn't lay off its employees. It didn't sell off the machinery needed to complete this contract, only to find that today, as we sit here, somebody is now completing that contract. And with what budget? They don't tell you. That's what we're facing. That's why I would submit, my lady, on what you were questioning my learned friend, Mr. Stilianu, a short while ago. This is a case with exceptional circumstances, particularly where it behoves SA Fence and Gate. Obviously, I don't want to be opportunistic or contrary to any of the interests of the other respondents. I can't speak for them. But, my lady, on the other respondents, let's analyze something else my learned friend submitted to you. The sixth respondent has now decided to abide. That's quite a concerning thing that's happened, because my lady's got before you affidavits on the replete documentation from the sixth respondent to explain why there was nothing wrong. Now, what that does is, if they've now decided to abide, that doesn't mean their affidavits with all the disputes of fact and all the things they raised go away. It only makes one have a bit more disquiet than previously, because one wonders, they are now letting you decide, my lady, without them being present, even represented by counsel, and they had a senior counsel on brief. Do whatever you want about profit disgorgement. That's what they're saying. And do whatever you want about setting aside our appointment. That's what Magnaletti is effectively saying by just walking away. Let's not allow them that. Then let's rather say, well, what my learned friend Mr. Simon was arguing, at the end of the day, Plescon Evans does say, unless my version is, as you correctly pointed out, mala fide, my lady, or, and it can be bona fide, but so far-fetched as to safely be disregarded, then you've got to look at my version. And all we then say to you, my lady, if you are not disposed to dismissing this application because of the hearsay criticisms, because of anything about jurisdiction, because of the abuse of process, and more importantly, and I'll deal with it briefly now with delay, then, my lady, at the very worst for all the respondents, and certainly the seventh respondent, this issue of who's really at fault, were the budgets really overshot, or do you only have part of the story because you don't know anything about budget overruns before 2011 and after 2012? All you have is an unsigned and undated extract of the Auditor General's report and an unsigned Nexus report. Very unhelpful, my lady, to tell you really what's happening over here. Did the new guys get maybe given 1 billion to finish off what we would have loved to finish off at 64 million? If that's the case, my lady, then as Shakespeare would have said, there's something rotten in the state of Denmark. We shouldn't be criticized. We shouldn't be thrown off. You should maybe hold over even on cancellation of the seventh respondent's valid tender and valid contract. I can't really comment because I don't know the case well enough about the other respondents and their appointments and their contracts, my lady. But what I can tell you is the SERA criticism has been overcome. Absent that, at best for the applicant, there's a he said, she said. And our she said gives you chapter and verse as to why we were not fronting. Our JV didn't die. We replaced Mavundla with a new BE, properly empowered, properly qualified bidder. The IDT, through its principal agent and its other agents who represented it and its other employees and officials, agreed that we were still constituted. There are letters to that effect. I won't take you to them because there really isn't any need. The principle is there. There is nothing in their case that dispels the good faith and the bona fides of the seventh respondent. We would urge you not to cancel the tender as far as it, even if you do, my lady, because I understand sometimes one says, well, but there was something irregular over here, we must cancel, because that was the cases say, don't suborn an illegality. I'm with you, my lady. In that case, this is exactly on preserved, such as they may be. We have to prove them. You're not giving us anything, my lady. We need to prove them. But preserve SA Fence's rights, accrued rights. Don't say that they must disgorge profits. Let's first see, my lady, whether we made profits at all. Because my lady will know, if I get a contract that goes over 8 years and I stop getting paid in 2017 to the tune that I have to because of many millions, I have to stop working. What's possibly the case is I might have made losses over here. Now, my lady will say, well, based on all pay and other strict cases, I can't even get my damages. I wouldn't take it that far. It depends, my lady. It depends on bona fides. It depends how much moral turpitude you ultimately find. Must be leveled at the IDT, the DCS, and all the other agencies. And my lady, that again is something that should at very worst for us be referred to evidence so that we can subpoena people and have a proper discovery process. My lady, my last submission that I wish to make is on the question of timing. Let's analyze that, because there have been cases that have said, specifically where the time lapse is so big as to demonstrate some kind of abuse on the part of the government agencies of these tenderers. One mustn't be harsh, and I know I'm paraphrasing, my lady, I hope you'll allow me that. One mustn't then be harsh to these tenderers, disallow their claims for accrued rights, and one mustn't be too benevolent to the government agencies. Let's analyze what happened here, my lady. 2011 was that previous tender and all of that. We come in 2012. We had nothing to do with all the skullduggery that my learned friend spoke about on SSO1. We're not challenging the proclamation because that has nothing to do with us. The proclamation we respect. It had to do with SFSO2 and we're in it. There's no problem. But my lady, that was 2012. In 2012, There's an Auditor General that does a report. There must be. In 2013 and in the 11 years that followed till today, my lady, there must have been Auditor General's reports every year. Scope is set on these issues. Every few months, Treasury set on these issues. Someone in those government departments must be tasked with saying, let's get the SIU involved. Now, I'm not arguing prescription, my lady. What I'm saying is there comes a time when, as a tenderer that has done an honest job of work, employing hundreds of people who now don't have employment, we have to get some form of light at the end of the tunnel. And all we ask on that light of the end of the tunnel, my lady, if you can see your way clear to it, and maybe you can't, and we respect decisions, do not cancel our tender and our agreement, because we were honest. And in fact, we complied. If you do, preserve our accrued rights and our right to show another court, it could be yourself, it could be another, it could be a court of law, who knows, that we are entitled still to payments. If there's damages we want to claim, the worst that can happen is we get dismissed with costs. But, my lady, give us our rights. And, my lady, if there aren't profits, for example, and we eventually show that, and that's why we would say it would be highly premature to order disgorgement of profits. I would rather than say refer the monetary issue, if you do cancel the agreement and the tender, my lady, refer the monetary issue all to oral evidence, because we would like a chance to show that there were no profits, and actually that we were highly damaged and in fact almost thrown out of business by this particular, let's call it, episode of what happened between 2012 and 2023. Lady, if I may just have one moment to take an instruction, I may then be able to put an end to my submissions unless you have some questions for me. Milady, I'm correct.
SIU case.
Against us. Not against
yes,
everyone.
Against you, right?
Yes. Yes.
But you are saying you are left out-pocketed.
Yes.
Then you can't pursue that relief here because you haven't counterclaimed.
No, we do have claims.
If I don't set it aside, you don't counter. You didn't counterclaim, so you can't pursue that relief here. You're not entitled to any relief. That's the end of the SIU case.
In fact, we couldn't.
However, if you are saying, if I do review and set it aside, then all pay says you shouldn't be out-pocketed.
You can make an order, for example, that our accrued rights will be preserved.
You'll make that case at that point,
yes.
Right? At the remedy stage. If
yes.
you're out-pocketed, you can prove that at the remedy stage.
Yes.
Is that what you're saying?
Well, we've got other pending claims already, my lady.
Yeah, I'm dealing with what's before me.
What's before you, my lady, is us saying, please don't cancel our contract. If you do, make an order similar to Gijima where you say this does not prejudice, and another court can decide it, or you in a second hearing, does not prejudice the rights that SA Fence may have to accrued rights or any other right they may have in law. You could make it that simplistic if you wished, my lady. But what you wouldn't find is that we must disgorge profits and we must do a statement of account for debatement at this time. Because again, there are disputes of fact which can't be resolved on paper. And equally, my lady, we couldn't come before you and ask for damages because that's a thing that must go on trial. We couldn't do it as a counter application.
Thank you.
Thank you, my lady.
As a court, please, my lady, I'm not going to be long. Firstly, with the IDT, we've got no issue that in law.
I beg your pardon. I'm sorry, my learned friend. I'm sorry to interrupt. We haven't met each other, and well, I hope to introduce myself to you one day. But just to interrupt you, to revert before you revert, in case you might want to say something about it in relation to the order. So we had spoken about. My lady, I had thought 30 days. Perhaps my learned friend can clarify. Not sure where we get it from because the latest version of the relief sword doesn't mention any particular time. Perhaps my learned friend can clarify that for us, what he means by that. And just in response to the order, my lady, naturally, our response to the order is for your ladyship to dismiss all the relief that affects us in regard to both tenders. and we would ask for costs of that payable by either the SIU or the IDT in that regard. It's only if you, or them, that would still say that we didn't do anything wrong and that the IDT or the SIU might have to bear those costs. As for Ladyship Leaders, perhaps my learned friend can clarify, because we seem to be under a mistaken impression, perhaps we saw it somewhere in these 9,000 pages, that there's a 30-day accounting, and he can clarify for us.
As the court please, my lady, that those periods are in our heads, and we proposed on the basis of cases like Vision View that they be given 30 days. But if they say they need 60 days, they must tell us what is the period that is more acceptable, because we don't want a situation where we say 30 days and are unable to comply with it. They must bring another application to extend. So if they say they need 60 days, we are happy with that, but they must indicate.
Thank you, my lady. If I could be of assistance to my learned friend, my instructions are that we would ask for 90 days from any order if my learned friend can live with that.
We can live with that, my lady. We understand that this comes from a long way, and obviously there's got to be an extensive exercise, so it will be fair in our view. We've got no issue against that.
Lady, sorry. Can I please just come in on that? I agree with the 90 days, just to align with everybody, and I think there's no disagreement. Just the last point, sorry, my lady, I forgot to mention. There is a scenario whereby, especially if you find nothing has been done wrong by our particular client, the seventh respondent, and especially if you think that it must either get referred to evidence or that it's premature to determine the disgorgement of profits. There is a scenario whereby costs can follow the result, and we could argue we're successful, but there's also a scenario where you could reserve the question of costs for later determination. I meant to just say that and I forgot.
Thank you.
I see Manal Front is still on the platform.
I'm just trying to get off. Thank you. Appreciate your assistance. Sorry to have interrupted.
No problem. My lady, I'm going to be fairly quick. With the IDT, we've got no issue with what Mr. Becker says, that in law they could be appointed as the agent. That's why we're not attacking their appointment, but we've raised our arguments insofar as they're concerned, that they were engaged in fiscal dumping together with the department. But what is important, and while I'm still on the IDT and also dealing with what Bakoni Sekelek raises, the issue of trustees, the IDT in fact agrees with us, and they specifically say that they agree with our approach on in the manner in which we've cited the trust. So with respect, it cannot be for Bakoni Sekelek to now raise this issue, but in any event, just to lay the issue to rest, what the SCA says in paragraph 25, in the case we refer to in our heads, my lady. If I may just read quickly, just 3 sentences. This is the task construction support case. After referring to the full bench decision where the full bench has said you need not cite all the trustees, then the Judge President says, or President of the SCA, I fully endorse that observation to the extent that it can be said to be a departure from existing authority. It is appropriate that our law of trust, as it has been evolving over the years, is developed along these lines. So this was a development of this principle that you need not cite all the trustees. I've also referred to the case of in the High Court, and if I may read paragraph 6 of that decision. We refer to it in there. The last sentence, it says, since trustees in a commercially active trust may change from time to time, it would be unduly formalistic to insist on trustees being cited by name in all instances. If there were questions about whether all trustees are acting in concert, Rule 7 could be utilized. I therefore grant the amendment. But the issue that we raise is that this issue is settled, and the IDT does not take a point with it. In fact, they say they support our position on that. Now, My lady, as to the argument raised that on the interpretation of the proclamation, Your Ladyship, of course, is correct to say what our opponents perhaps overlook is where the proclamation says, is where after dealing with, and this is what Manyanet Front raises, where it says, but relevant to, connected with, incidental, it says, or ancillary to the matters mentioned in schedule in the schedule, or involve the same persons, entities, or contracts investigated under authority of this proclamation. Now, we say this it covers DCSS F01. But my little friends, in their heads, they said what you must do is to strictly interpret this. We then, in our supplementary heads, raised the issue that this is not how, in the modern era, that you interpret provisions of the business. At the context, you look at the text and the purpose. Now, and while dealing with that, the decision that he relies on, it was an interim interdict decision in the urgent court. It may still be changed by the review court. So this is not the decision that Your Ladyship can rely on. But what we say, and we raise this in our supplementary heads, let us remember what these tenders are about. Technically, it's two separate tenders. But in fact, we know that in fact it is so tender 2 is a continuation of what happened in tender 1. If Your Ladyship has regard to the contract that was signed, which again was signed 4 months after the so-called cancellation, after the cancellation. In that contract, which is Annexure 823, at pages 005-1064, the Ladyship would recall, so this contract, even though it was cancelled, they then sign it, but they say its effective date is 6 months before, which is 9 November. You will see, my lady, that the services that Bakoni Sekelek were engaged on, it was 6 stages. Stages 1 is inception, 2 is concept and viability, 3 is design development, 4 is documentation and procurement. Now, this is when now the tender was cancelled after they reached stage 4, but they were contracted to go all the way to stage 5 and 6. Then the tender was cancelled because of the irregularities. So when tender 2 comes, it is the continuation of stages 5 and 6. It will be artificial to then say these tenders are not related. In fact, we would say, in fact, it is actually the same. It's a continuation of the first tender. The Bakoni deals with it at paragraph 143 of their answering affidavit as 005-91. And again, they emphasize these stages, these 6 stages that they were contracted in the first tender to do 6 stages. But then it was cancelled when they were about to proceed to 5. And then, of course, we know that the second tender proceeded with stages 5 and 6. So to now say these are separate tenders with respect, if one considers the context, if one considers the text of the proclamation that we quote and the purpose, one cannot argue that these tenders are different. And as I've indicated, the Mbuyane edition is not of assistance. The review court may still differ on that. Now, the prescription point, my lady, I'm not going to with respect, waste time on that. Our investigation was authorized only in August 2017. We issued the papers in December. As to whether prescription could have ran even before then, it's a matter that we can perhaps debate before the full court when time comes. But it will be it's an academic exercise for the people.
Are you threatening me?
No, I'm not.
Which full court are you talking
then
about?
I withdraw that statement if it's well as a threat, my lady. I withdraw it. All that I'm saying is, with the facts of this case, there is no prescription. So we need not enter into that debate. The same with the dispute of fact that my learned friend raised. It's an academic exercise because he can't tell you even a single fact that he says here is a dispute of facts. He simply says that at a disadvantage, there's imbalance in powers. The state has got all these machineries, but of course we said we've got the constitution, the PFMA, the procurement prescripts. Everyone can see if these have been complied with, and even them, they should know. They should know, particularly starting from the first tender. They were simply appointed as unsolicited bid when there were no grounds. They should know that. There should not be any debate about it. The argument that we still can't declare the contract void because it has been cancelled, with respect, again, it misses the point. My learned friend seems to be arguing on private law remedies, that the contract is cancelled, therefore you can't cancel it again. We are relying on public law remedies. When it was concluded, there was no authority to conclude that contract. It was unlawful from the beginning. Whether it was cancelled or not, it's irrelevant. And once it was unlawful from the beginning, and it was not supposed to have been concluded in the first place, then the payments that followed after that are irregular payments. So that is why there's a difference. There's a difference in that. And then of course he says, and again, one can see that he's arguing the private law grounds. He says there was nothing untoward with the 2.6 million that was paid due to the cancellation of the contract. It may be so if the contract was lawful. It may be so that in terms of their rules, engineering rules or whatever, that's what must follow as a consequence. But that is where the contract is lawful. Here we say the contract is unlawful. Therefore, they were not entitled to that in the first place. Then my learned friend who dealt with the issue of the professional indemnity with respect, and he says Magnaletti in his affidavit says the letter of intent by Igoda was not good enough. But that is not what Magnaletti said in the report. And what we rely on is what Magnaletti said in the report. In the report, it does not even mention that there was a letter of intent from Igoda. It doesn't mention that. What it simply says is that Igoda only submitted the 5 million professional indemnity. That's all that it says. Nothing more. So then in the affidavit, of course, now they say that the letter of intent had different conditions, but that's a different reason. In the report, there was no letter of intent. All that they mention is that and it's important that I read what the report says. It's at page 001-1684. This is what it says under Igoda now. It says, submitted a professional indemnity insurance of 5 million from Aon and 5 million from Glenrand. That's what they say. They don't mention that there was a letter of intent where Igoda says, if we win, we will then get 15 million rands cover. They don't mention that. So the allegation that Igoda was properly disqualified with respect, it is wrong. Because Magnaletti itself, it did not have the cover. And I'm sorry, back on a second leg. And even in my funding argument, I said, yes, they were allowed to then give either a letter of intent or a code. They gave a code, nothing wrong with that. But the unfairness is in the disqualification of Igoda. Now, my learned friend says, but yes, ours is a code, but so what? Because then a code is a code. It's not different from letter of intent. It simply says, should we be appointed? We may get the 15 million cover, we may get the 20 million cover, but the issue is that at that stage you don't have it. The same with IGOD. They said if we succeed, we'll get 15 million cover. So, but then with respect, we don't understand the criticism against IGOD. Then I'm not going to really enter into the debates about what Pumela said, what the All Pay said. We've made those very clear in our heads. Pumela is wrong. There can be no doubt about that. Then coming to the seventh respondent. The seventh respondent, well, at the beginning, my friend still raised the issue of common law. But in our heads, supplementary heads, we refer to the Battlestar decision. It's a 2004 decision by the Constitutional Court. It's a well-known decision, which basically said from now onwards, we no longer have common law review. So my friend cannot still continue with the argument that the somehow Ledla must be understood to mean this tribunal can only adjudicate on common law reviews. With respect, Battlestar at paragraph 25, it's exactly what it says. Paragraph 25 of that decision. And coming to the SIRA issue, the issue is about what did the tender say firstly? Because the tender said, and my learned friend referred to other provisions later on. Well, I referred to this document, Annexure CDT 17 at 001-1767. So the issue we made, at the top it says all documents are to be submitted by the tenderer or by all joint venture partners if the tenderer is a joint venture. Magnelletti then goes and says, all the 4 members of the joint venture submitted the SIRA certificates. But we now know, and my learned friend also accepts that, well, he says, but we as a fence gate, we did have a certificate. He does not say Robex did have certificate. He doesn't say Godian submitted the certificate. I understand he's arguing that in terms of perhaps also in terms of the law, only SA fence may have been required to give that. But the issue is, what did the tender document say? Firstly, what did Magnelletti say? And he accepts that Magnelletti also says all of them submitted the certificates, which is not true. And we say Magnelletti favored SA fence and gate. That's what we say, because they would not have said all the four bidders submitted the 4 certificates, because it's not true. It's simply not true. But that's what they.
What if Magnelletti misinterpreted the requirement, which is what Mr. Staliano said essentially?
Well, if they misinterpreted the requirement, assuming that the requirement says only 1 member of the
Mr. Bolo, sorry, I can't remember.
Yes, it's Mr. Bolo. Assuming they misinterpreted that. All that we say at page 001-1779 in their report, then they simply should have ticked 1 box.
And there's no irregularities established, Mr. Mutepe.
No. I accept that SA fence, as Mr. Bolo say, they may not be. We cannot self-standingly say they did anything untoward by submitting 1 or 2. We cannot say that. But what we can say is that they were favored by Magnelletti. And I've already made a point which no one has responded to, that starting with the appointment of Magnelletti, it means all the appointments are unlawful. But with regard to this,
so don't move away from this point.
Yes.
He is saying the requirement in relation to the SIRA certificate was it applied to what the tender refers to as SQJV members. I even asked him what SQ is. He said it's a CIDB grading for security work. And only those who have this grading are required to have the SIRA certificate.
My lady,
It appears to me that Manyeleti misinterpreted this requirement.
My lady, in at page 001-1589, this is the affidavit of Deloitte, and it quotes what the legal requirement is.
Okay, sorry, let me go there. Give me the citation again.
001-1589.
001.
He quotes from the Act what security services means, because the requirement is that those who render security services must have a SIRA certificate. And this is what it says. It's a lengthy, but whoever is going to be working on that fence, that is included as security services. And therefore, and that is what the argument was, that because of this fiscal dumping, everything done in a rush, Manyeleti does the evaluation when it is not authorized to do so, and it favors SA Fence and Gate. And if a leadership finds that SA Fence on its own did nothing untoward, we obviously that is the finding of a leadership, but we say the contract of SA Fence, it cannot stand. Perhaps it may have a case in the just and equitable remit, but the contract cannot stand because of the irregularities committed. Firstly, in the appointment of Manyeleti, because leadership would recall, Manyeleti is the one then who evaluates even the tender of SA Fence and Gate. So on the ordinary principle and Seal versus Van Rijn, once Manyeleti's appointment is set aside, and no one has dealt with this argument, even in response. Once the appointment is set aside, all the subsequent decisions, they fall by the wayside. And as I say, and I did say, if SA Fence suffered damages, it did to make, and we say that we should succeed with costs as a court, please.
Thank you. We've come to the end of today's proceedings. Thank you very much for your assistance. Judgment is reserved and the proceedings are adjourned.
As a court, please, madam.
Thank you, my lady.
Thank you, my lady. Thanks. Thank you, my lady.